Good afternoon. Welcome to the fourth webinar in our Allies and Advocates series, the New South Wales Mental Health Review Tribunal, Balancing Competing Rights. My name's Carmel Tebbit, and I'm the CEO of the Mental Health Coordinating Council. I'd like to begin today by acknowledging the traditional owners of the land that we're meeting on. For me, that's the Gadigal people of the Eora Nation, but of course it will be different depending on where you're zooming in from. I'd also like to acknowledge the contribution of people with a lived experience of mental health conditions and the difference that they have made to our understanding of mental health and to mental health reform in Australia. Thanks very much, everyone, for joining us today. We've got over 200 people registered to attend this webinar, so it just shows that there's a great deal of interest in this topic. And we've got a wonderful lineup of presenters to talk with you this afternoon, so I'm sure that you'll find it's very, very valuable. We are due to finish at 3 p.m, but we do have a lot to cover, so it may go a little bit over time. We are recording the webinar, so if you need to leave early, you'll be able to access that recording. We're hearing from three presenters today: Maria Bisgoni, Dr. Charles Doutney, and Coron Henderson. And we're then going to have some questions to the presenters from Athena Field and Darren Wagner. And please, if you've got any questions or comments, put them in the question and answer box or in the chat function, and we'll try and get to those as well. So let's move to our first presenter. I would like to introduce Maria Bisgoni, and I think Maria's camera will be turned on and Maria will appear on our screens. Maria is the Deputy President of the New South Wales Mental Health Review Tribunal, a role that she has held since 2003. Maria has also been a member of the Corrections, or now Justice Health Board, and worked as a legal aid solicitor for almost 2 decades in both New South Wales and Victoria. Welcome, Maria.
Thank you. Thank you for that warm invitation. And thank you for the opportunity to speak today about the work of the Tribunal, and in particular, how the Tribunal balances competing rights. It is a precious and fundamental right of each of us to make decisions about our lives, and in particular about medical decisions, even unwise ones. However, if a person is assessed to be mentally ill or mentally disordered and detained in a mental health facility, or subject to a community treatment order, which is a compulsory order for treatment in the community, usually made by the Tribunal, this right may be curtailed. Curtailing this right is so serious that it can only occur if certain legal tests in the Mental Health Act are fulfilled. And in essence, this is what the Tribunal's role is. The Tribunal is a check to ensure that involuntary treatment orders only occur if in limited circumstances and where justified, and only after a rigorous legal process. The Tribunal is a quasi-judicial body, and it is independent. This means, while we don't have the formalities of a court, we must make decisions that are according to the law, based on reliable evidence, and in an open forum where the parties can be heard. So I think it's important to go through how the Tribunal makes its decisions. To outside observers who happen to be flicking through our annual report, you'd find that the vast majority of applications made to the Tribunal are in fact upheld. Those statistics might indicate to those people that the Tribunal is a rubber stamp. That is not what the Tribunal is. That would be a mistaken view. And this is because the Tribunal can only make decisions where there is proof of the need for an order to the satisfaction of the Tribunal to the balance of probabilities. So how does this work in practice? We expect treating teams to attend the Tribunal to give oral evidence based on written reports that are provided to us. We expect to receive the written notes that document a person's progress during an admission. And the tribunal is able to ask questions in relation to the evidence that is given, as is the person's lawyer. The lawyer may also make submissions, seek clarification, and put the wishes of the consumer to the panel. And sometimes consumers are not represented, and this is often the case at community treatment order hearings. It is most important that a consumer has the opportunity to also ask questions, probe the evidence, and express their point of view. And that can be done with the permission of the tribunal. I think it's important to note that a check for consumers in the Mental Health Act is that having a mental illness or a mental disorder is presumed not to be an impediment to being represented at hearings. And lawyers appearing before the tribunal are entitled to have access to the medical report in advance of the hearing, have an opportunity to go through the report in a quiet space with their client, and attend on the person's behalf and put questions and make submissions. And it's also important to note that if a consumer is not represented, that they have that same right. In fact, they do have the same right to access their own reports, subject to, in limited cases when the tribunal might, for reasons of safety, decide otherwise. It's also important to note that the tribunal has very flexible powers, and the idea behind this is that the tribunal should be able to go about its business to obtain the best evidence possible with which to make a decision. So the tribunal can adjourn a matter if it's not satisfied with the material before it. It can only adjourn matters if it's in the best interests of the patient, and it can do so if there are gaps in information and further clarification is required. It can also do so if the treating team or the patient require a further period of time to really put their case and be prepared for the hearing. Another important check on the tribunal's power is the duty of fairness that we owe to parties that attend the hearing. And in essence, the duty is in three parts. That is, the consumer has the right to know what the case against them is. They need to be given ample notification of the hearing. They must be given an opportunity to be heard and give their own case. And the tribunal must make decisions based on evidence, and the decision must be free of bias and impartial. This means that the tribunal does not attend hearings with a bias towards one party or another. Tribunal hearings are also recorded and available if a person is going to appeal or for some other request. Another important protection is that tribunal hearings are open to the public, and this provides transparency in tribunal decision-making and accountability. Now, the fact is that the public in general don't attend our hearings. They don't even know where they take place. Many of them, as you know, take place in mental health facilities and by AVL link. But the important point is that the tribunal doesn't operate in secrecy. And this is important for there to be public confidence in the work of the tribunal. And this is a good thing. Another check on the tribunal's power is if we've got it wrong. There is a right of appeal to the Supreme Court. Also, if a party requests discharge, if a person requests discharge from a mental health facility and that is refused, the tribunal is obliged to conduct an appeal hearing and hear the evidence of the treating team that is maintaining the person's status at hospital as an involuntary patient. And these are important protections for the consumer and also protections that are really applicable to the public at large for there to be confidence in the work of the tribunal. It should also be noted that even if a community treatment order is made, if there's been a change of circumstances or new information that arises since the making of the order, the consumer has the right to ask the tribunal to vary or revoke that order. Another really important aspect of the tribunal's work relies on the tribunal adopting the guiding principles in section 68 of the Act. And in a way, these guiding principles are a check on the way the tribunal conducts its business. And I'll read those from the legislation. That is, that a consumer should receive the best possible care and treatment in the least restrictive environment to enable effective care. Care and treatment should be timely, high quality, and in accordance with the professionally accepted standards. Every effort should be made to involve consumers in their recovery and treatment plans and their expressed wishes considered. Care and treatment should be of a kind that enables people to live, work, and participate in the community. And people should be given information about the treatment, advised of alternative treatment, and supported to pursue their own recovery. I'd also suggest that another important check in the process is not just the legal requirements that I've referred to, but the expertise of the panels that sit and make decisions at these hearings. If it is a single legal member, and it will almost always be a single legal member if it's the first hearing before the tribunal, known as a mental health inquiry, that will be a person that has legal expertise. If it is a 3-member panel, it will involve a psychiatrist, a lawyer, and a third person with other suitable qualifications, often a social worker, a psychologist, or a registered nurse. In addition, the legislation requires the tribunal to have consumer and carers as part of its membership. All our members undergo training in relation to the law, the processes, and the training is regular. An important aspect of our training is how to conduct fair hearings and conduct fair and effective hearings. There's also been in recent years targeted training on ensuring that tribunal members involve consumers and carers in the hearings. We conduct performance appraisal of our members. There's been quite a bit of training on recovery principles and trauma-informed care. Now, a tricky issue that arises in tribunal hearings from time to time relates to the rights of carers to be notified about attending tribunal hearings and the right of the consumer at a hearing. I say this is tricky because the legislation was amended some years ago to ensure that carers would be able to support their loved ones by having information about a range of matters, including notice of a hearing, and that is to ensure that they would be able to support their loved one during the admission and, crucially, when the loved one is discharged from hospital. Sometimes consumers are unhappy about having the carer attend a hearing, and it is often the case that the tribunal will have a consumer say that they would prefer not to have the carer at the hearing, or in fact, the mental health facility, even knowing of its obligation to notify carers of the hearing, won't do so if the consumer has said that they would prefer the person not to be at the hearing. So the tribunal is involved in a balancing act of competing rights when this situation arises. No two cases are the same, but in a case like this where the tribunal has to weigh what information the carer has and whether or not that is critical to the decision that it has to make. It balances that consideration with the possible effect, perhaps the distress of a consumer having that person present at a hearing. And weighing up all those considerations, the tribunal would then decide whether or not the carer should remain at the hearing or be involved. I think that what is clear to me is that the tribunal is very aware of the fact that at the end of the day, when the hearing's over, the consumer and carer need to pick up, the consumer and the treating team need to pick up, and that it's most important that those important therapeutic relationships are not endangered or imperiled because of what occurs at a hearing. And we're very sensitive to that and sensitive to any suggestion that by involving a carer, it might cause distress to a patient. Luckily, there are flexible powers in the Act. So if it is necessary, absolutely necessary to hear from a carer, the tribunal can do that by hearing from the carer separately. But there are mechanisms to allow critical information to be considered by the tribunal that allow these processes to be done in a way that is sensitive to the consumer's needs. I just want to end on the human side of what we do. It's probably the most important thing that we do. We are dealing with human beings, some of whom have a trauma history, some of whom come to hearings feeling that the case is going to be stacked against them. They might feel that they have done something wrong. After all, they are attending a tribunal hearing. They might find the experience nerve-wracking and daunting. They might even be experiencing mental ill health at the time of the hearing. The tribunal's job is to do all it can to involve that person or their supports in the hearing so that person's point of view can be known and expressed. It's important that the consumer is made to feel as comfortable as possible in a hearing. Now, we have about 150 part-time members, and all tribunal panels have slightly different approaches. But what they have been trained on is the importance of letting consumers know early on in a hearing that their point of view is important and they will be heard. And that is best usually done in my view, by inviting the consumer to put their point of view at the earliest opportunity. And if a consumer has any concerns in relation to their care and treatment, the tribunal hearing can be a really good place to have a full discussion about any concerns, and also it allows a consumer to put their express wishes and aspirations to the panel. I hope that at the end of a tribunal hearing, that consumers who leave the hearing feel that they've been dealt with fairly, that they haven't been part of a ticker box. I hope that they would feel that decisions are made on reliable evidence according to law. I hope that they would feel that the hearing is a place where issues of concerns may be raised and discussed with the treating team, and that they've been able to put forward their expressed wishes and aspirations. And I hope that they would feel that they have been dealt with courtesy, dignity, and respect. And I am also hoping that even if the outcome isn't what they'd hoped for, that they leave the hearing feeling that the process has been rigorous and fair. So thank you.
Thanks very much, Maria, for that very comprehensive account of the Mental Health Review Tribunal, and also explaining some of the intricacies of how it operates. We're now going to hear from two Mental Health Review Tribunal panel members. They're going to provide shorter presentations. So I'd like to introduce our next speaker, who is Dr. Charles Doutney. And Charles has practiced as a consultant psychiatrist since 1979 and worked as a community specialist in numerous senior roles. He has been a part-time Mental Health Review Tribunal member since 1996 and a lifelong advocate for mental health reform. Over to you, Charles.
Thank you, Carmel, and thank you, Maria. You have sabotaged the notes that I've prepared in your talk, in your comprehensive account of the role of the tribunal. So I'll shift ground a little bit from what I'd intended, but not a lot. Who is a psychiatrist? What does a psychiatrist have in terms of experience that can assist the tribunal to meet those requirements that Maria has outlined in her introductory talk? Now, to be a psychiatrist is not a simple process. The minimum educational training for a psychiatrist is higher school certificate, 3 years undergraduate course, 5 years general medical course, 1 or 2 years as a junior medical staffer within the public mental health system before they can be registered as a medical practitioner. And then if they choose to pursue a course in psychiatry, to undergo 5 years of practical training, which is essentially within the public sector, dealing with people with major mental illnesses mostly, but also with people who have ordinary distresses and concerns and difficulties in their journey in life. So that's a very minimum. During that course, the trainee is expected to present written cases for examination and assessment, to undergo personal assessments, to meet a number of exams, and to select an area for the last 2 years of training, which is going to be an area that they would consider choosing for the rest of their psychiatric career. At the end of that period of time, a person is entitled to go into private practice or to choose to remain and work in various fashions within the public sector mental health services. So that there is a minimum from school to beginning to work as a psychiatrist of some 14 years of training, not all of it in mental health. Now, what does that training set out to provide? It sets out to teach people how to conduct a mental health assessment. Now, I've chosen the word health assessment with deliberation, because it is not to diagnose that somebody has a mental illness. It is to make an assessment of what is the nature of the problems or conditions or concerns that a person being presented or presenting themselves for an assessment might actually be. It is as important to determine that the person does not have a mental illness in general assessments as it is to determine that they do. I think it's important to understand that. What else? It teaches you how to recognize the patterns of symptoms. I'll have to use some medical terms, I regret doing so, but to recognize patterns of mental phenomena and behavioral phenomena that occur regularly together and are considered to indicate the presence of a mental illness, and to not confuse those patterns with ordinary distresses that people without mental illness might feel. So there is that component to the assessment as well. An assessment would also include assessing risk of harm to self or others. And harm can take many forms. People think because it says harm, because the Act says harm, it means physical violence or aggressiveness. But harm can be loss of contact with your family. It can be loss of income. It can be loss of money. There are a variety of harms which seriously impair a person's life. When you are working in public sector psychiatry, you are making assessments like that day in, day out, year in, year out. It also teaches you the effectiveness and limitations of the treatment modalities that are available. No psychiatrist with experience expects that the medications they're prescribing is going to cure people of mental illnesses, cure every people, cure some people, cure all. They learn to accept that there are limitations to what can be done. It is not simply a matter of prescribing medications to people. The next concern is that in working in public sector work, especially when you work across community and hospital, you see people with illnesses, their families, their carers. You see them in centres, you see them in hospital, you see them in their homes, you see them when they don't have homes, you see them in a variety of stressful and difficult circumstances. If you look after people for a long period of time, you get an idea of how the illnesses progress, stay stable, remit, relapse, which otherwise would not be available to you. When you come in to the tribunal, you bring that experience with you. And in arriving and in obtaining that experience, you also arrive at an understanding of the variety of approaches and the variety of needs that patients have. Because a lot of the disability and the unhappiness that's associated with persons with the kinds of conditions that justify involuntary treatment, I've lost my track there. I'm sorry, I'll stop. Now, that's an incredible amount of experience. What you don't, that you bring in to a tribunal, that experience is available to you as a panel member in interpreting the evidence that's being put to you by the treating team, or the applicant of the community treatment order. It's available to your fellow panel members if they have concerns about the evidence that's been presented and want to get some and want to ask some questions about what's been said and what might it mean. Panels tend to adjourn and to discuss any concerns that they might have amongst themselves at some point during the hearing, and what skills and what knowledge the psychiatrist has is available to people who might wonder about the evidence being presented. Maria pointed out very clearly, I had a section here, what is not the role. It's not the role of the psychiatrist to provide a second opinion in a hearing. That would be a ridiculous expectation, and it would be beyond the capacity of a psychiatrist at a panel hearing to conduct their own history, their own mental state assessment. The psychiatrist is doing what the other panel members are doing. He or she is assessing the evidence that is produced during the hearing and determining whether or not it meets the requirements for making an order, and then whether the objectives of the Act justify making the order. It's not that, the other thing is that the hearing is not there to debate the rights and wrongs of involuntary treatment. It often comes up as an issue during the hearings, but the panel is not there to give opinions or argument about whether it's reasonable to have a Mental Health Act, to have coercive treatment or not. It is conducting a hearing within the provisions of the Act. I think the last thing that I wanted to say is that you learn a lot about the sort of problems, the sorts of issues, the sorts of concerns that people suffering from illness, people from families, people in the families of people with the illnesses, people who are carers for family, you come to learn the sorts of questions and issues they've had, and you have had innumerable discussions with people about those issues outside of tribunal hearings as a psychiatrist. The knowledge of those concerns is something that you bring. And the final thing that I wanted to say is that while one might learn a lot in the course and the practice that I've described, one of the most important things that one learns is how courageous and how adaptable, in a sense, the people you are meeting with and dealing with are in the course of what is a very difficult life for very many people. And you earn a tremendous respect for people who experience mental illness and for people who care for them and who live with them. And you bring all of those things into your role as a psychiatrist member. And that's, I think, what I wanted to say.
Thanks very much, Charles. Your many years of experience really do add a very valuable perspective to our discussions today. So thank you for that. And our next speaker is Coron Henderson, who is the Principal Policy Advisor at the Mental Health Coordinating Council and a member of the Mental Health Review Tribunal. Coron has worked in mental health since 2003. Her work primarily focuses on mental health policy, sector development and translational research, and she's a registered clinical psychotherapist. Welcome, Coron.
Thanks, Carmel, and thank you very much, Maria and Charles. As Maria said in her presentation, the other or third member of the tribunal come from a diversity of mental health related roles. And I just wanted to make sure that people knew that that includes people with lived experience and consumer and carer advocates. And people like myself with a policy background and clinical experience. I consider it a great privilege to be part of the work of the tribunal, and my background informs my understanding of the importance of the role of the tribunal, ensuring that the objects of the Act, including the rights of consumers, carers, and the community, are upheld. Equally, the work I do on the tribunal informs the policy work I do. It really keeps me grounded in the reality of the service delivery context. Members like myself who have experience of the mental health and psychosocial disability sectors have knowledge about the services and programs available to people, their carers and supporters. And as a member, I'm sometimes able to bring that experience to the hearing and assist with some information about community-based services and identify where people can access information that might better support them navigate what's a very complex service system. I think that my clinical and policy experience also informs my understanding of people's concerns about coming before the tribunal. And I see our role as vital to discussions about what represents best and least restrictive care that's safe and effective. Panels really do work as a team, identifying the nature of the application and the issues to be determined. But what other members bring to the hearing often is that trauma-informed, recovery-oriented focus. And in my view, it's important that this approach is given voice, especially in relation to whether the treating team propose something that recognizes a person's strengths, has the potential to maximize their functionality and independence, and consider dignity of risk alongside community concerns and the responsibilities of the healthcare system. Panels try really hard to support a person feel as comfortable and safe in a hearing as they can, so that they really can make it clear that their perspective is as important for us to hear as that of the treating team. And other members, like myself, are particularly interested in a person's social history so that we can consider whether a person will be well supported back in the community. And we'll inquire about details of the discharge plan so that we can identify whether that plan is capable of being executed in a way that maximizes recovery outcomes and safety for people and their carers. I'm keen to communicate that we're interested in hearing about more than a person's symptoms, but to understand their circumstances and aspirations for the future. The feedback that we get can provide us with rich insights into their lives and their relationships. In my view, what tends to lead to a more therapeutic hearing is when consumers have the opportunity to say something at the beginning of the hearing, which is something that Maria touched on, rather than having to wait until everyone has said their piece about them. This can be so distressing if their history contains traumatizing events for them and others, and it can leave them feeling that the tribunal's decision is a foregone conclusion. Likewise, we're keen to hear from carers and support persons who really know the person and can give depth to the tribunal's understanding about their lived and living experience. Sometimes a person's been in hospital for a short time, seen multiple clinicians, and has been given a treatment plan developed with not as much involvement as might be desirable. As a panel, we may draw attention to ways in which collaborative planning can enhance care and treatment and give a person a better opportunity to engage, stay well in the community, and not end up back in hospital. And one of the things I'm always keen to see happen is that all those that should be informed about the proceedings have been informed, that the person has the support they want in the hearing, a friend, a family member, or a peer worker, and likewise that carers and guardians have been given the opportunity to participate and contribute if they want to. In my opinion, one of the most important tasks the tribunal has to grapple with is how we balance those competing rights: the individual's right to liberty and safety, the freedom from unnecessary intervention, their right to treatment, protection and care, and the right of the community to safety and protection. It's often a challenging decision that we need to make, and none of us do it lightly. Thanks very much. Back to Carmel.
Thanks very much, Coron, for that presentation and your understanding of the community managed mental health sector and trauma-informed care. I think is so important to the operations of the Mental Health Review Tribunal. We're getting some really lovely and interesting comments, mainly through the chat function. I might just share a few of them. Thank you, Coron, for mentioning dignity of risk. Acknowledging this in a person's future planning is very important. Thanks from a full-time care and mum of a son who has chronic schizophrenia. And another one about someone who said, I've never been informed about any of my son's hearings. The last case rang me one day before to text me to call back, made me aware, but did not make me aware that there was a tribunal hearing. My son was disappointed too. So I think it just shows that this is a really important topic, and I'm very pleased that the Mental Health Coordinating Council can host this webinar and increase people's understanding of how the Mental Health Review Tribunal operates. And on that note, we're now going to move to our Q&A session, and we have two people who work in the field, Athena Field and Darren Wagner, and they're going to ask some questions of our presenters. So I'd like to introduce both of our panelists to ask the questions. Athena Field is the Peer Community Education Program and Workforce Practice Advisor at Wellways. Athena has 27 years experience in community services as a peer support worker, a trainer and peer educator, and a program coordinator. So welcome, Athena. And
thank you.
Darren Wagner is the manager of the peer support team at the Eastern Suburbs Mental Health Service. He is a post-traumatic growth advocate, a former police officer, and has done extensive work as a lived experience researcher, peer support educator, and support worker. Welcome, Darren.
Thanks, Carmel. Thanks, everyone.
So, Athena, I think you're going to ask the first question to our panelists, and hopefully our panelists will all reappear so that you can see their faces.
Great, thanks very much. Both Maria and Coron mentioned, how carers can be involved in the tribunal process, and particularly Coron, you mentioned that you hope that they are more informed. So my question is around more about the peer support worker. So how could they be more involved with the tribunal hearings and inquiry? How could they better support the participants that they are supporting?
Who wants to go first from the panel? Maria? Great, thank you.
Yes, thank you. Look, I'm happy to answer that. Look, the tribunal's certainly aware of the growth of the peer workforce in New South Wales and very much welcomes their involvement in hearings. Not only in hearings, actually, I would say prior to hearings, we think that it would be of great value to consumers to be able to speak with a peer prior to a hearing, for a peer to attend the hearing and either be there as a person who is there to give good moral support or to enable the person to articulate their views. But most importantly, I think that at the end of the hearing, when the treaty team goes back to its job, the tribunal moves on to the next case, and often you will have a consumer who's devastated by an outcome, and to have that opportunity to debrief with someone who has had similar experiences is so important. I personally am very keen, I know the tribunal is very keen on having peers involved in hearings. In fact, I can say to you that this year we have started to collect information on if a peer does attend to a hearing, because we'd really like to get a sense of the extent to which they're involved. But I think any encouragement or support to have a peer attend is great. And bearing in mind that the Act does talk about in its guiding principles that everything must be done that's reasonably practicable to obtain the consent of a consumer to treatment. But if they're unable to do so, they must be given support in assisting them to make decisions. Now, who better than family, carers, and a peer support worker to do that job? So look, they're a very welcome addition. We know that it is not a level playing field, particularly for consumers that attend our hearings and that are not legally represented. So whatever supports can be put in place to level that playing field, to assist the consumer in expressing concerns, wishes, desires, expectations, future aspirations, is something that we wholly embrace.
Yeah, I would also just like to say there that quite often in hearings, I will ask if there is a peer worker available in that particular hospital, because it's clear that the person would benefit from some support other than the treating team at that particular time. And sometimes there is somebody and sometimes there isn't. There's obviously a real shortage of peer workers, and it's something that MHCC is very much pushing right across both the community and the inpatient setting.
Thanks, Coron. Thanks, Maria. Now, Darren, I think you've got a question.
Yeah, thanks. Thanks, Carmel. So again, obviously we're all meeting here because of the impact of COVID. We've had some questions in some of the consultations that I've had in supporting people, because we've had outbreaks on inpatient units where people are actually being there as an involuntary patient. So I guess would the tribunal consider, this was a question that's been raised, would the tribunal really consider potentially being discharged if there was a COVID outbreak on a mental health unit and they really felt unsafe in that space? So I don't know
I'm
if that,
happy-
maybe Maria.
I'm happy to
Okay,
answer
Maria.
that.
Yep.
I'm
Thanks,
happy to
Maria.
I think that we need to go to fundamentals, which is that the tribunal can only make a decision based on the evidence before us as to whether or not ongoing involuntary care and treatment is appropriate and absolutely necessary. And I'm certainly aware that there have been some outbreaks in wards, and naturally that would cause great distress to patients. The tribunal doesn't really get involved beyond saying at this point in time, when we are conducting this hearing, has the treating team met that high bar, which is the person continuing to experience symptoms of ill health, and are there, and because of that, is there a risk of serious harm to the person or others? And is this the least restrictive option consistent with safe and effective care? Having said that, I mean, certainly there have been hearings where consumers have brought along a support person, a carer, and have said, it's awful here. I could get better treatment at home. In the acute stage of the illness is over, and I would actually get better more quickly if I was at home in my own environment, supported by my own family. So the tribunal does have flexible powers depending on what the evidence that we accept. But an option is to discharge a person into the care of their carer if we can get an assurance that the person would be looked after and that they wouldn't harm themselves or others. And we get that in writing, which is pretty much the same test that is on the treating team. And also bearing in mind that the treating team has an ongoing obligation to assess whether or not involuntary care and treatment is appropriate, is the least restrictive option, whether or not the terms of the Mental Health Act continue to be satisfied. If not, they must discharge.
Thanks, Mary. And just also thank you for being a champion for getting, really encouraging that peer involvement, from the earliest stages. So, I just wanted to acknowledge that.
Thank you. Thank you. Very exciting, I think.
It is.
It is indeed.
Yeah.
Now, Athena, I think you might have another question.
I had quite a few that were coming from the consumer perspective, but I believe the panelists have really answered a lot of those. But I was going through the Q&A,
Yes.
and if maybe I'll ask this question.
That would be great.
Yeah. From anonymous attendee, given evidence and data suggests a very high percentage of people accessing the public mental health system have experienced complex trauma. How do you include a consideration of a person's trauma experience in your recommendations for treatment and hospitalisation within the Mental Health Tribunal?
Who wants to start? Charles?
Charles, I think.
Yes.
Well,
great.
It's a difficult one to start with a sensible answer because the tribunal doesn't order treatment. It makes orders for involuntary treatment. It tries to ensure that the care plan presented to it is consistent with standards of care, with professional standards of care, but it doesn't direct treatment. So it can't direct people to provide recovery, provide treatment for past trauma. Now, I don't know how you get around that. Many of the services would not know how to do it anyway, even if you were to tell them to do it. There aren't many people with trauma within services to provide that care, but we can't direct it.
But
so
what
I don't know the answer to your question.
But what we often do, Charles, and you've probably heard me suggest it on several occasions, is if it's clear from the evidence that somebody has a history of trauma, and for example, we're being asked to approve a CTO, I will ask about the referrals that
Oh, well,
the
yes.
community team will, are you going to be looking towards making referrals to, you know, appropriate services that are going to be able to assist whoever it is? We don't go too directly into what the person has experienced, because that can be very traumatic in a hearing, but it's just a kind of flag that in the work of the community team, they can make referrals to an appropriate practitioner who could, you know, a psychologist or whatever. And you might ask the consumer, would you be interested in engaging with a psychologist when you're back in the community? And they may say, yes, I would. And then that flags it for the community team to make that referral.
Yeah, sure. One can do that, but to really introduce it as a standard component of care, the work has to be done elsewhere than the tribunal. I mean, that's the work of the service.
Yeah.
To have guidelines, to have training, to ensure that new things like peer review workers, like peer support workers. We had some hesitations about it when it started, I have to admit. But clearly, with passage of time, it's become, I hope, obvious to services how useful to patients and sufferers and peer workers are, regardless of what health workers might think. If people find peer workers helpful, then they should be part of the care plan. Now, we had the same problem years ago when the government introduced legal representation at magistrates' inquiries. We had concerns as professionals. What was going to happen? We were going to spend weeks in courts arguing about whether coercive treatment was right or wrong, or whether it should or shouldn't ever happen, and so on, or was it going to work out? And I've spent many magistrates' hearings with registrars and with magistrates to try and get the system working in a way that wasn't confrontational, that wasn't traumatic to patients or staff, and that actually worked. The tribunal itself was met with some resistance from the services. It takes time. What I've found working on the tribunal over a long period of time is that the panels develop skills. They develop experience. They begin to, if they haven't started with knowledge of what it's like, for example, if they've been mainly lawyers who haven't had much to do with those things, they certainly learn as they are faced with the decisions that have to be made and the information that's presented to them at hearings. And there tends to be a common consensus about the sorts of things that need to be done that didn't exist 30 years ago. So that this, while there are dissatisfactions and it's still a changing process, the process itself has changed dramatically over the years and is so much better than it used to be.
Thanks, Charles. Now, Darren, last question.
I've been waiting. No, I've been waiting. Thank you so much. And I just wanted to acknowledge Charles, just thank him for that honesty around that in service that as we move forward, there can be, look, it's not easy. So change is never easy. I'm happy to report that the peers are extremely valued in service currently. As a peer manager, I think I get requests weekly around new initiatives, around having peers in almost every multidisciplinary team that's coming up. So I guess to tie in what we've been talking about is having the importance of having peers in that tribunal space and supporting someone through that journey. I guess my question is to anyone on the panel, either Maria or Charles, is Does the tribunal currently offer any kind of support just beyond the resources that are available freely on the web? And I guess I'm specifically more interested in something around something like the HEDI, the Higher Education Training Institute's 2019 kind of their accredited training program, which is specifically there to help support and upskill people. Because just because I have a lived experience doesn't mean that I feel comfortable supporting somebody in a system that I'm not well versed in. So over to you, Carmel, and the panel. Thank you.
I think, Maria, that might be you.
I think that's you.
Well, I guess the short answer is not yet. But certainly I can see value in it. And I could just say to you from the an executive perspective at the tribunal, we are very much interested in the idea of, we are developing an idea currently of having a tribunal advisory group made up of consumers and carers, and I might also say looking at hopefully the prospect of employing someone on a very part-time basis as a consumer and carer engagement officer. So that could be the beginnings of that kind of training, but certainly I think, no, it doesn't exist now. I mean, we do things in an ad hoc way. I mean, for example, today might be described an ad hoc way of imparting information about the tribunal, but not specific training, but that would be really good. I mean, we do a lot of training. We do a lot of training at mental health facilities in relation to the Mental Health Act. We certainly are involved with consumer and care groups. So I think that some kind of sort of education around the tribunal, its process, how one could be involved in supporting a consumer hearing would be a really valuable thing to have.
Hopefully out of this discussion, this is the beginning of that. And please reach out to me. I'm interested.
Thank you. Thank you. I certainly will. Thank you.
Go back quickly and briefly to my earlier comments. I think a lot of the resistance was not so much an unwillingness to change, but a lack of understanding of how helpful it might be, and concern that it might be harmful rather than helpful. So it wasn't malevolent.
No.
There is always resistance to change, especially if you don't know how valuable the change is going to be.
You don't know what you don't know. And the point's well taken, because most of whenever I've come across anything that felt tokenistic, was I've also acknowledged and reflected it was coming from a caring place of not knowing as well. So I just want to thank you for that.
Thanks, Darren. There are quite a few comments and questions in the chat function, and we're certainly not going to be able to get to them all, but we will record them and try and respond to those after the webinar. There is one that I might just ask. Families, carers and patients are often advised the tribunal will take place with very little notice. What are you doing to ensure fairness and equity to the tribunal process? Tribunals can be re-traumatizing if they are not conducted well, fairly, and from a trauma-informed perspective. Maria, I think you've really covered that in your introductory comments, but maybe there might be a little bit more you might like to add.
There is some difficulty in this and I'm talking about civil hearings, which constitute the bulk of our hearings, in that the responsibility for providing notice to carers resides with treating teams and community teams. And the tribunal is dependent on those teams fulfilling their obligations. I could say to you, for example, at a mental health inquiry, it's called a mental health inquiry, the first hearing before the tribunal, because the first part of the hearing is about whether or not the consumer's rights have been respected when they're brought into a facility, including, have they been given their statement of rights, not just given it, but explained in their own language. Have they been notified of the tribunal's hearing? Have notices of hearing gone out to carers? So certainly, and in fact, there is a power to adjourn a hearing at a mental health inquiry if those things have not occurred and the tribunal considers it's in the best interests of patients. But that's not the way to change behaviour. I mean, as we are doing with peers, we are also trying to collect information in relation to when carers attend, to try and get a sense of how often, or perhaps how little, the obligation of treating teams occurs in terms of notification of carers. But look, I'm in contact with carer groups and consumer groups, and this is a project that the tribunal is keen to continue to work on. But look, things have slowly got better in that it was once upon a time, it just was notice of the mental health inquiry. The law actually requires notice of all tribunal hearings. Certainly, if we are aware that a carer has been notified and that their involvement in the hearing hasn't been facilitated by the treating team, after we ask a few rudimentary questions to ensure that it is appropriate to proceed, we will try and involve the carer. And I should just give a plug to everybody out there to say that if you have a carer who has a mobile phone and wants to be involved in a tribunal hearing, if you get the little PEXIP number, you can dial in and be seen on your screen and be involved in the tribunal that way. So there are problems. We are trying to work through them.
Thank you, Maria. Coron?
We do often say, you know, would you like us to take the number of the carer or support person, because we're happy to try and dial in.
Yes.
And we often do that. We try 2 or 3 times, we'll try on different numbers. So we really do try and facilitate that, because it is very upsetting when you know that somebody has wanted to participate and that they haven't been given adequate time or notice to be involved. So sometimes we get people and they're at work and they'll go outside and take the call or whatever. It's not the best way, but we do make every effort to involve those that the consumer would like to have with them.
Thanks, Coron. Thank
As
you.
a panel member,
Now,
I can confirm that we do that quite
a lot.
Great.
Yeah.
Great. I think the audience will be pleased to hear that. Now, Maria, you've been answering a lot of questions, but I understand you also have a question for both Darren and Athena.
Oh, thank you. I will ask that question, which is, are there any protocols or guidelines in relation to the nature and boundaries of engagement with consumers receiving involuntary care under the Mental Health Act? This is in relation to peers. And if so, are these standard across health or determined at a local level?
Athena, is it okay if I take it first of all? Okay, thanks so much. So look, Maria, that's a great question. So look, I'm pleased to say that, look, usually that there's really very little boundaries around peers being able to offer that support. I think the things that come to my mind, first of all, is often a safety issue. So whenever we're supporting people in an inpatient setting, because the amazing peer team that I get to support, we actually work across the emergency department, our psychiatric emergency care center, our PEC unit, our mental health ICU unit, and inpatient units. So we work across all of these units, actually even fully PPE trained so that we're COVID ready to go. So I think it's really around risk. So if a person is really that unwell, and often it's not a good time to be trying to support someone in that space anyway. And then secondly, I think that the biggest thing again is that we've noticed some of the bigger challenges have been around COVID. So we actually have a dedicated mental health COVID positive wing that we've just had to put together. So quite of it, so when we're talking about challenging environments, often being, we've been talking about being an involuntary patient, and then that burden's just been, doubled or tripled by then having a COVID positive diagnosis test come back. So in those spaces, we've as a peer team, we've said, look, we've created a peer hotline, a peer phone line, to offer to those and phones and tablets being provided in that space as well, so that people in that inpatient unit can reach out during certain days and hours. to seek some support around concerns around upcoming tribunals, or just peer support in general. So I guess that's probably the simplest answer, is that, you know, luckily, again, we're across almost all inpatient. Well, the current model is we're across all inpatient units, as well as community teams. So there's very little boundaries. Athena, would you like to add it?
Yeah, sure. Coming from a CMO perspective, so, you know, as a peer worker, we're not based inside the hospital. So there will be some kind of limitations and boundaries according to our policy and procedures, obviously. You know, in pre-COVID times, there would be no issue to access, you know, a patient or participant within the hospital system. But COVID has taught us, like Darren has said, you know, the risk management. So we would need to see, you know, from the public health order that we are essential workers. So we should be able to have some access, knowing that there's those parameters that are put around that. But very similar to Darren, we try to ensure that, you know, there is that opportunity for a participant or patient to have access to their peer worker who they've been working with, who they've built that trust and that rapport. Sometimes we are the only designated person in that person's life. So, you know, may not have many visitors. So a peer worker will ensure that they have that opportunity to visit them, to talk to them. When you talk about the nature of engagement, there is a power imbalance. So when a participant and a patient is within the hospital, there is always going to be that power imbalance. So as a peer worker, it's essential that we do see them in the hospital, especially if they're in that involuntary care, in order to give them that information, the resources that are available to them, you know, to try and sort of tip the scales a bit. So, you know, they're in there feeling quite distressed that they're there. They may not have that many visitors. A peer worker will come in and hopefully encourage that hope, encourage the recovery, and see it as an opportunity for healing if that's possible. Yeah, and provide the appropriate information, knowledge of their rights and responsibilities, and the reasons why they are there for involuntary treatment. So we try our best to ensure that we can visit them, and obviously through our policy and procedures and public health orders to take those into consideration as well.
Thank you. That's really comprehensive. Thank you.
Yeah, thank you. Thank you, Athena. I think that gave us a real insight. And Darren. So that brings us to the end of our webinar. We have gone a little bit over time, but I think everyone will agree it was just such a fascinating conversation, and so fortunate to have the five of you with all your different perspectives and experiences coming together. Very much appreciated. Thank you. So thank you to Athena, to Darren, to Maria, to Charles and Coron for your contribution today. I know how busy you all are, so really it's been wonderful that you can share your knowledge and wisdom with the audience. I know that they very much appreciate it. As I said, we haven't got to all of the questions and comments in the chat function, but we will endeavour to follow those up after the webinar. And before I do say goodbye, can I also remind everyone that the Mental Health Coordinating Council has produced the Mental Health Rights Manual. It's available on our website. We recently launched the 5th edition, so it has been comprehensively reviewed. It's got extensive information about the Mental Health Act, the role of the tribunal, and a whole range of other matters. It's a really great resource, so I would very much encourage you to check it out. It is on our website. Thanks again to our panel. Thank you to everyone for joining us. Have a great afternoon. Goodbye.
Thanks, everyone.
Bye-bye.
Thank you very much. Thanks, everyone.
Thank
Bye-bye.
you. Bye-bye.
Bye-bye.